if we have a meeting and we talk about bad care that we provided, that could get used in a legal case if this patient or their family sues us.
Welcome everyone to the Tennessee NAEMSP YouTube broadcast. The legal implications or legal protections offered to quality management programs. And we'll discuss this in general and get into the specifics for Tennessee. Joining us today, we have a number of panelists. First off, let's start with Kathy Wire. Kathy, could you introduce yourself for us?
Sure. I'm Kathy Wire. I am the Executive Director for the Center for Patient Safety, which is a federally recognized patient safety organization and the only one at this point that's working with EMS agencies extensively. I am an attorney by background, and so a lot of what we do is work with agencies in different states to implement the protections that are available through the PSO law and help them protect their quality work.
Excellent. Thanks for being here, Kathy. Also joining us is Doug Wolfberg. Doug, could you introduce yourself?
Hi, I'm Doug Wolfberg. I am an attorney with Page, Wolfberg, and Wirth, a former EMS practitioner, EMS director, state, federal level EMS official prior to my career as a lawyer, and I'm happy to be with you.
Thanks for joining us, Doug. Also here with us today is Joe Holley, who should be familiar to everybody in the Tennessee chapter, but for those who might be watching outside of Tennessee, Joe, could you introduce yourself?
Well, good morning, everybody. I'm Joe Holley. I'm an EMS physician, primarily in the Memphis area, where I do medical direction for a number of EMS services in the area. But I also serve as the state EMS medical director for the state of Tennessee.
Excellent. And also with us today is my co-host, Frank Tift. Frank, go ahead and introduce yourself.
Hello, everyone. As he said, I'm Frank Tift. I also am an EMS physician working in the Chattanooga area. I focus most of my work on air medical. I'm the medical director, one of the medical directors of LifeForce Air Medical Services out of the Chattanooga area. And then also on education of EMS physicians. I'm the program director of our EMS fellowship in Chattanooga.
Great. Wonderful to have the whole gang here, but let's just jump right into it. Doug, I'd like to start with you and kind of tell us what's the issue here. Why would an EMS agency need to have any sort of special protections for its EMS quality management program?
Because if properly structured, these programs foster candor in the review of medical care provided and allows the agency to take an unvarnished look at errors and mistakes that may have contributed to patient harm and that could be prevented in the future. And again, if properly structured, the agencies can do that and at the same time minimize the fear that any records or conversations pertaining to improving their care would be protected from discovery and from admissibility in a legal proceeding.
Let me drill down with you a little bit on that discovery. So what would be like a scenario in which I would be concerned about that?
Well, say there was a medical misadventure.
Okay.
For example, there was improper airway management or an airway management case in which the patient suffered a bad outcome, even if we don't know that it was necessarily, caused by a misadventure or improper care. When the agency wants to drill down in that and look at the quality of care furnished by the practitioner, we don't want the fear of discovery in a legal case to have a chilling effect, right? We want to be able to look and really drill down to root causes. And we want to remove the fear with these laws that, well, if we have a meeting and we talk about bad care that we provided, that could get used in a legal case if this patient or their family sues us. So it's really meant to remove that impediment in the process of looking at or evaluating care.
Yeah, I'm also thinking maybe outside of even an event of medical misadventure, if you will. If, say, along those same lines. I routinely look at my airway outcomes, and we try to monitor for esophageal intubations or whatever the case may be, and we identify some of those. Would those records of our longitudinal look at airway management process and outcomes also be protected outside of the particular event?
Yeah, when we're looking at quality performance indicators, clinical performance indicators, in the manner you suggest, that also should be protected under most of these laws. Certainly, it looks to be protected within the scope of the Tennessee law. I would add that that kind of review has the added benefit of also usually being de-identified, which means if you get a subpoena for records pertaining to this particular patient, those records are generally not responsive to that kind of request or subpoena. So for both of those reasons, that kind of information should also be protected under these laws.
Yeah, and it would seem that these laws vary a little bit from state to state. Are all states generally covered by these sorts of laws, Doug?
Most states do have a peer review protection or QI protection or similar law that protects certain records, but not all, from discovery and from admissibility. Those laws vary in their formality that's required in this process. They also vary in whether or not they expressly mention EMS agencies and EMS practitioners. That's a shortcoming in many states, Tennessee included. It would be nice if the law specifically named ambulance services, EMS agencies, and EMS practitioners, EMS medical directors, for example. So, that provides a little bit of opportunity for it to go sideways if a judge, narrowly construes the scope of the protections. But that is a shortcoming we've seen in quite a few state peer review protection laws.
Sure, sure. And we'll get to some of the particulars in a moment, but Joe, from your perspective as a medical director, what would be your perspective on in the absence of having a this sort of law, or absent having a sort of formal QI process that gets protected by this? What would you see as the implications of that for how agencies manage their quality?
Well, I think Doug's comments touched on that quite thoroughly. Obviously, in the absence of such protections, the idea of people objectively looking at their mistakes, potential mistakes, or errors that occur, they are much less likely to do so. Certainly, if they're concerned that the investigation into those errors or mistakes might lead to legal consequences related to those.
Yeah, so Frank, also being an EMS physician, what's your take on all of this? Would you really see agencies kind of holding back on their quality management programs if they didn't have legal protections? Or let me put it another way, do you think most EMS agencies are even aware of these legal protections and their implications?
I'd certainly reiterate what Joe just said as well. I'd say if the protections weren't there, I would certainly expect that various QA, QI, or CQ committee sort of or bodies probably wouldn't be getting the full story from their crews, certainly, if they're worried about reprisal and worried about potential consequences. So the importance of these laws and these protections can't be overstated. You kind of threw a second question at me towards the end there. What'd you say? What was?
Well, do you think they would actually hold back on their
Oh, yes.
quality management programs?
Yeah, I believe that they would certainly hold back and try and kind of protect themselves through potentially not necessarily revealing everything that happened, but
Yeah,
going through all the specific details of the situation.
yeah, let's not look under that rock.
No.
Sure, sure. So, Kathy, you have a little bit different perspective on all of this, I think. You work with a patient safety organization. So first, tell us a little bit about what a patient safety organization is and how it may be of assistance to EMS quality management programs, particularly if they have one of these medical misadventures that Doug referred to.
Okay. The Patient Safety and Quality Improvement Act of 2005, to be technical, creates the opportunity for patient safety organizations. And PSOs, as we call them, voluntarily participate under the Act to work with healthcare providers, gather data, um, generate learning to the extent that we can based on what we get from our participants. The flip side of that is that by participating with a PSO, a healthcare provider or organization can receive incredible protection for their quality and safety work. Essentially, they get to define what we call their patient safety evaluation system, which is generally what they're already doing or what they would like to do. And once they do that, all of the work that takes place within that system is protected by privilege and confidentiality at the federal level. And that protection supersedes state law. So if you have a state law that is less protective, the federal law will supersede that. It also provides for a national standard of protection. So if you're working in an interstate environment or a regional provider of services or a national provider of services can work with a universal level of protection throughout their organization, which is really helpful. As Doug mentioned, there is an incredibly complicated network of state law in this area. I live in Missouri, which has no protection whatsoever for EMS. They have been consciously excluded from the state protections. We aren't really sure why, who's mad at who, but year after year they try to get the protections, and year after year the legislature says no. That's actually how we got into working with EMS in the first place, because Missouri's EMS providers came to us and said, hey, can you develop a PSO for EMS, because we're kind of hanging out here and we want to change that situation. So the PSO is an organization you participate with, and you work together to define the PSES. And also, there has to be some reporting to the PSO. That's part of the deal. The federal government wants PSOs to be able to gather information so that we can aggregate it and basically work to share learnings about what our organizations are doing. I will tell you that's been a little bit of a slower uptake than we had anticipated, but it's there, it's moving. So that's essentially what the PSO is. It offers a lot of the same protections that Tennessee does. In fact, in looking at the Tennessee law, it's almost patterned after the protections of the federal law, which predated it. And it also defers to the federal law, which is really cool, because in some states they try to nibble around the edges of the federal law and make it harder to enforce. One of the advantages of a PSO for someone in a state like Missouri or Kentucky, I just looked up how many border states Tennessee has, and it ties with Missouri for having the most. There are 8. So if you're providing care where you're touching one of those other border states, if their protections aren't as good as Tennessee's, then you're subject to being brought into litigation in that other state with its lesser protections. The advantage of participating with the PSO is the protections apply no matter what state litigation takes place in. I love to see laws like the one in Tennessee. They're great so far as they go. One other advantage of working with a PSO is federal courts are required to recognize the PSO protections. Federal courts generally do not recognize state protections for this kind of work. And there's a new case in Missouri that summarizes all that and once again says we don't necessarily follow state protections for quality and safety work. If a organization participates with a PSO, even if they're sued in federal court, which can happen, I won't get into the details of how, but it can happen, and then all of your work is protected in that federal court proceeding as well.